here. Yeah, my joke is I always say I'm a lawyer and a librarian, so you know I'm fun at parties. But I'm really happy to be here today. What I want to do over the next hour and a half or so is try to persuade you, one, that copyright isn't as complicated as you can feel like it feels sometimes. And that copyright really sees and values the work that you do. So I'm not coming in to be the copyright cops or to scare you or anything else. I think it's actually pretty straightforward and understandable. So I'm going to do my best to sort of say that as much as I can. What I've got here is sort of a general agenda. I thought it might be nice to start with some foundational stuff, some of the fundamentals, talk about what it means to build on existing work. How do we bring in stuff we didn't make to our work in different ways? Talk about what it means to share our work out to sort of, the way when you use a platform like YouTube or WordPress or whatever, that changes the rules in some ways. And then I'm going to do my level best to leave a lot of time for questions and discussion at the end. That said, if you ever have a question or a comment, if I say something that sounds unfamiliar or strange, that sort of piques your curiosity, if I say something that gets you excited and enthusiastic and you want to know more about something, drop that in the chat. Unmute and ask a question. I really want this to be as much of a conversation as it can be, recognizing that we're on Zoom and it's a little harder than if we were all sitting around a table together. So that's my plan for the next little bit. Talk through these things we've discussed here, and then leave a lot of time for questions and discussion. But please do jump in at any time that you want. So let's start with the copyright basics. And I find it's often helpful to talk about copyright with a specific concrete example. So I'm gonna start with this one here. This is something that came across my screen a couple days ago and made me chuckle. This is somebody tweeted out this image describing their experience with textbook publishing. It takes some materials from a popular movie, from an old Star Wars movie. It recreates them in the form of this meme, and then they've added some text as well. And so the question I want to ask is, who owns this stuff, right? I saw somebody named Lenny shared it out. I think I recognize some of those characters as maybe something Lenny didn't make. So the question I'm going to use to guide our discussion here is who made that thing? Who owns that thing? How can I use that thing? So we're going to keep coming back to this example as a way to think through copyright ownership. And let's start with the basics, the fundamental stuff. Copyright at its base is really simple, and it's right there in the name. Copyright is the right to make copies. If I control copyright in something, I have some control over the ability of other people to make copies and share that thing in some sense. It's not much more complicated than that. And if you've got that aspect of it, you've got 60% of copyright down pat already. Other basic things to say about copyright is lawyers sometimes say it follows the pen, meaning as soon as you write something down with your pen, that thing has copyright in it. Just like ink flows from a pen, copyright flows from that pen too. And that the same thing is true with a paintbrush or with your fingers on a keyboard or anything else. So if you're back channeling, talking to a friend right now going, oh my God, I'm already so bored by this presentation. What am I doing here? You're a rights holder. You control copyright in that snarky message or that snarky tweet or whatever it could be. As long as something is original, meaning it wasn't already out there in the world in some sense, it's creative, meaning there's a little bit of you and your creativity in there. And it's, a lawyer would say, fixed in a medium of expression, meaning other people can see it or hear it or perceive it in some sense. It's protected by copyright. And as soon as that thing exists and is protected, the one who made that thing, generally speaking, owns that thing. We say copyright is an author's right. So when I make that snarky tweet, I am the rights holder in that thing. And then last but not least, to say that I control copyright in something is to say that I control and can give away, loan, etc., any number of rights to use that work in different ways. So we often talk about that as copyright is a bundle of sticks that you can give away individual sticks to people. So I could say, Charlotte, you can use my work on Tuesdays and Thursdays, but not Monday, Wednesday, Friday. Or Patty, you can use this stuff when it's raining outside, but not when it's sunny. I can give a license, permission to anybody under just about any terms I want. So when we talk about sort of sharing copyright, that idea of a license, if I can give away some parts and keep other parts, is going to be important. So that's the quick and the basic. We're through 75% of what you need to know about copyright now. If I make it, I own it. It happens automatically. I don't need to have the little C in a circle. I don't need to register it with anybody. And I have control, which means I can give other people permission to do stuff with it as well. So that's the basics. The other thing to say is copyright exists in this sort of family of related rights that are sometimes called intellectual property, things like patents on inventions, trademarks on images, or other indications that an item in commerce comes from a certain source. Those things are distinct, but we often talk about them as sort of a family. So I just want to situate copyright in there. Copyright is unique in that it happens automatically, which some of those other things like patents don't, and it lasts a long time. But that's the sort of the quick and easy version of copyright. It's this thing I talked about. It exists in the context of this family, and that's the basics. Let's add a little nuance now. Let's pour a little nuance on top of those basics I talked about. Going back to the example I showed a minute ago, what's happening here is no one person made this thing. Several people worked together, right? Somebody with a camera recorded the movie. Somebody else wrote the script. The actors performed something. They're wearing costumes that people have made. Lots of people worked together to create even the underlying images here before we get to the text, before we get to the tweet and everything else. And the way the law talks about that process, when more than one person works together to create something, is we use this term joint authorship, which means that more than one person worked together, and a couple things have to happen under the law for joint authorship to occur. The first is that both people have to have intended to be joint authors. So the person running the camera on that movie had to say, I'm doing this as part of a larger effort to make a movie. The costume designer had to say, I'm not making these costumes for a fashion show. I'm making them to be part of this film, right? Everybody has to intend to be joint authors. And then the other piece is that each person who is a joint author has to have contributed separately copyrightable content, meaning everybody who gets to be a joint author has to have done something that's original, that's creative, and that other people can see. So George Lucas, the writer of that Star Wars movie, might say, I was really inspired by this guy, Joseph Campbell, who wrote this famous book. Well, Joseph Campbell did something original and creative, but he didn't contribute anything to the movie itself. He only contributed sort of ideas and concepts, not the actual copyrightable stuff. So Joseph Campbell is not a joint author in the context of that image. I like this example on the page here, because comic books are a nice example of joint authorship. One person generally does the sketching, the pencil part, and then the other person adds the colors and the ink. The image exists in the context of both of those contributions. And so our analysis of ownership recognizes both of those contributions. The other nuance, and this is sort of directly relevant to the work that we do, is a lot of times when we create things in the context of work, of being paid to do certain tasks, we move into the space of what's called the work made for hire doctrine, meaning you did that thing with your own two hands, but because you were being paid to do it, because you were directed to do it by your employer, the legal fiction is that you were basically working as the hands of the institution itself. So when I make a web page for NC State where I work, I sit down and write the code and move the pictures around and everything. But because I get paid to do that, and because some of my job responsibilities include doing that work, the law would say, well, you created that thing, but NC State as an institution is the rights holder. They're the ones who control that work. And in the context of what we do in terms of extension, a lot of materials fall under that. If you want to know specifically how to understand copyright ownership in the context of works made in and through extension, Rule 06.01.01 is the place you want to go. And if you ever have trouble falling asleep at night, I strongly recommend Rule 06.0101, because there's a little bit of legalese there. It gets a little jargony. But basically what it says is that when you're doing things under the aegis of extension, something that you made not off on your own, but in the context of extension work, the presumption is that it is work made for hire in that sense. The law said, the policy says it shall be, quote, directed work down there. But that's the idea, is that work's made sort of with and in partnership with extension, borrowing that brand and everything. So that's a really good question. Patty asks, would this be applicable to volunteers who are not employees? So the language itself says, created by those employees within their employment at North Carolina State. So this part of the policy is specifically speaking to people who are employees themselves. If you're a volunteer, you'll want to have a conversation with the folks in extension about how that relationship does or does not fit, but the policy as written applies specifically to employees working within the scope of their employment. And that within the scope of their employment is important too, right? If I take a picture as part of my work, that picture belongs to NC State. If I go out on the weekends and just go walking in the woods and take beautiful pictures, that's not made within the scope of employment, so that's still my thing. This policy and every policy that I'm familiar with talks about within the scope of employment as being an important part of that conversation. Really good question. Okay, so that's the ownership stuff in a nutshell. The last thing to say is as you can see, in the interest of simplicity, the law often collapses a lot of nuances that exist on the ground, right? The law really likes the idea that one person or one institution owns something just because it's simpler to administer. But we know in practice, tens of people, hundreds of people contribute to the work that we do, right? This slide deck that I've made benefits from teachers I've had, from experiences I've had, from mentors throughout my life. And while the law collapses that into a singular, Will is the author, he created the original creative and fixed work in this context, or NC State is the author, Will did it within the scope of employment. We know, in fact, creation is much more complicated than that. And so there is a movement afoot to do a better job of recognizing the diverse set of influences and contributors to a work, whether or not they are the legal authors in some sense. And so I share the credit taxonomy as one example of a nice way to say, and Charlotte, thank you for that link to the copyright policy itself. I appreciate that. So I share credit as a way to say that when we talk about who is the owner of a thing, that's a parallel discussion to who gets credit for a thing. And even in cases when the law flattens a lot of those nuances, we still have the opportunity as ethical practitioners to recognize that nuance and acknowledge this person isn't a rights holder, but they've been instrumental in my understanding of this issue. I think they deserve some credit as well. So that's the basics. Coming back to here, you can see that, as I talked about a minute ago, ownership in terms of the creativity that's involved is complicated here. Actors, performers, lighting technicians, people who use the camera, costumers, etc. The law, though, is going to collapse ownership into a much simpler way, which is the movie stuff belongs to Lucasfilm under work made for hire. Everything in the movie belongs to Lucas and thus now Disney. The text and the meme probably belongs to whoever added the text. And then Lenise, from my time in textbook publishing, I give you, probably belongs to her. So most of the things, including a lot of the images that we use, ultimately the answer to who owns that thing is related to who made it, but a little different, and often can be more complicated than, oh, Lenny owns that, or Disney owns that, or whatever. Sometimes we need to be a little bit more nuanced in terms of who owns the thing, either by seeking out images that are simpler, and I'm going to talk about some of those using the Creative Commons, or by engaging with some of the copyright limitations and exceptions. And that takes us into the next part of our conversation. When we bring in stuff that we have not made, that can feel very complicated. I want to suggest that it's not as complicated as it can feel. And so I want to give you in particular these 3 questions to answer any copyright question. So if you create something yourself, you own that thing. If you are not creating something yourself and you want to use somebody else's work, you're asking the question, okay, who owns it? Do I need to get permission? How do I think about that stuff? If you follow these 3 questions, you will come to the right answer every single time. So I want to walk through these 3 questions next. Before I jump into that, are there any other questions that are lurking or lingering? Anything I've said so far that was confusing or exciting or you really want to know more about before we get into the 3 questions?
Will, would you just reiterate for us, what did you mean at the beginning by fixed? When we were looking at the creative and so on, could you just tell us again what fixed means?
Great question, absolutely. The law says fixed in a medium of expression, and what they mean by that is somebody else can see it or hear it or perceive it in some way. So if I record a song, singing a song doesn't create copyright, recording it to an audio device makes it fixed in a medium of expression. Seeing something in the world doesn't create copyright, but clicking on the button on the camera and fixing it as a photograph or a digital image, that's what it means by fixed. So writing it down on the page, sending out the tweet, that sort of thing.
Okay, thank you so much. Perfect.
Yeah, for sure. Great, really good question. Thank you for that. So, okay, so let's dig into the building on existing work stuff. As I say, with this image here, you see people building on and then building on and then building on the building on, right? Somebody creates the movie, somebody else creates the meme, somebody else responds to the meme, somebody else comments on the meme. Creation is, as we know, inherently an act of engaging with what's come before and building on it with something new that we've added as well. So this building on is where I think the really exciting stuff happens. When you find somebody else's work that you want to build on, the first question to ask yourself is who, if anyone, owns it? And I think that if anyone piece is especially important because copyright is limited in a lot of different ways. Copyright is limited in terms of what it covers and how long it lasts and a lot of other things as well. So these are a few examples of ways that copyright acts as sort of a limited right. Nobody owns ideas, for example. So the idea that the special theory of relativity, nobody owns that. Nobody can control that. You can talk about that idea, you can think about that idea, you can respond to that idea, and it's just not protected. Not because it's not valuable, but because it's so valuable that if we locked up ideas themselves, we couldn't do anything. We couldn't talk about anything. We couldn't exist in the world if the idea of an alphabet could be owned. And so anybody who wanted to use an alphabet had to pay a fee, right? That would be ridiculous. Similarly, nobody owns facts about what's happening in the world. So if I went outside every day and I said the temperature at noon is 87 degrees, and I just wrote down on a big list the temperature it was at noon every day outside my house, I wouldn't have any copyright in that because facts are not sufficiently creative. They're just a fact about what's happening in the world. So you never need to worry about getting permission to reproduce facts, that sort of factual information in whatever form it takes, even if it's presented in a chart or a graph or a table or something else, facts are not protected. Copyright generally doesn't protect words or short phrases. And then maybe most significantly, copyright doesn't protect most works made and published in the United States before 1925 or so. We often talk about that as the public domain, the body of resources that nobody controls copyright on, so anybody can use however they want. As I say, the public copyright lasts for the life of the author plus 70 years or before 1925, and that's just by statute. And that's a feature, not a bug of the copyright system. The reason we have copyright in the first place is to incentivize people to create things with this short-term monopoly so that in the long term, we can stock a robust body of resources that are in the public domain for everyone to use. That's the purpose of copyright. Like Lana Del Rey, copyright is born to die. I see we have a question here. So Andrea asks whether articles that are made up of ideas, facts, words, and phrases are copyrighted. The individual ideas, facts, and words and phrases are not protected by copyright. An article that could bring those things together so that it's, not just one word, but many words strung together into sentences and paragraphs and that sort of thing, that would be protected. But that's an interesting idea, right? That you can take a set of things that are not protected by copyright, either bring them together such that there is copyright protection, or select them and arrange them in such ways that there might be sort of a limited copyright protection as well. Here's a nice example. Every day I go outside and I note what temperature it is. And I notice that the temperature has gotten hotter and hotter as it moves into the summer. And I write a poem that sort of reflects my created experience of the increasing heat. And that poem includes the fact that on Monday it was 87, and on Tuesday it was 89, and on Wednesday it was 92. The poem itself is protected by copyright, but if you wanted to pull out the unprotected facts and use them, you still could, right? So the poem taken as a whole, if you wanted to take my whole poem, you would need to think about copyright and maybe permission or fair use or these other things. But the fact that I have included unprotectable facts, words, short phrases, doesn't mean that you can't still pull those words or short phrases out. So you could take my poem and say, I don't really care about your crappy poem. I just want to know the temperatures for the days. And then you could reproduce 87 Monday, 89 Tuesday, whatever I said before. So that interesting dance between, works are protected when they are original, creative, and other people can see them, but they often build on or incorporate things that are not protected. And so you can pull those things out. The easy example from my own experience is if you are a student who has ever had to buy one of those mammoth books of like the collected works of William Shakespeare. Shakespeare's plays are in the public domain, right? They were before 1925. They were published and widely available. Nobody owns the works of William Shakespeare. You can make your own copy. You can sell that copy. You can perform the plays. You can do whatever you want. The reason those books are so expensive, other than the paper and the ink, is those books generally add annotations and commentary and discussion. And that annotation and discussion is protected by copyright. So you couldn't just physically copy and digitize those big collected books of William Shakespeare because of the annotations. But if you just pull out Hamlet, if you just pull out the play, that's not protected by copyright. So I don't know if this is helpful and clarifying or just getting really muddled and confusing, but copyrighted works can include works that are protected by copyright and material that is not protected. The law doesn't change just because those things have been mixed together. Clear as mud? There's also a question here about a chart with all of the data. That's a really good question. A chart that merely mechanically reproduces uncopyrightable data. So I go out and take all those temperatures I talked about, and I put them in a chart that is Monday, Tuesday, Wednesday, Thursday, Friday. No copyright protection. You can copy that chart, you can reuse that chart, you can change that chart. There's no copyright there in the first place. We're going to talk about attribution in a little bit, and you may still want to give me credit for that chart, but that's an ethical, not a legal obligation. I see your question, Andrea, and I'll absolutely answer it as well. If I were to take that same set of data and visualize it in a creative way using colors and shapes and symbols, there's a level of presentation past which the presentation itself is creative. Still, the underlying data is not protected, but my chart is not just a mechanical representation of the unprotected data. My chart is a beautiful work of art in and of itself. That's when it crosses over from unprotected facts to protected visualization or sort of representation of that work. Really, really good question. We're getting into the nuances here in a way I really appreciate and like. Andrea asks if I would repeat what life plus 70 means. Absolutely. So when I say life plus 70, what that means is if I am a rights holder, if I create a work protected by copyright, I control copyright in that work for my entire life, for life. And then after I pass away, interest in that copyright, control of that copyright passes to my partner, to my children, to whoever I choose to inherit that right. And they have it for another 70 years. So copyright lasts for the life of the author, as long as the creator lives, and then for 70 years beyond that as well. That's what life plus 70 means. Really, really good questions here. Thank you for asking those. Keep them coming, please. So the public domain is this huge body of material that we can draw from that represents most of written creation over time, and eventually will reflect just about anything because we want to have a robust body of open materials that everybody can engage with in whatever they want. So Patty asks, would the pre-1995 rule apply to various editions of music scores, etc.? Good question. Copyright purports to be medium neutral, meaning images and text and music and dance and everything else are all treated mostly the same under copyright. We don't have separate terms or lengths for music versus text versus anything else. Music, as you may know, is a little more complicated because there can be a copyright in the written music and then a separate copyright in the performance of the music as well, right? So I write a score and I have copyright for life plus 70. You then perform that work in a certain way. Your performance may have a separate copyright in the way you specifically performed it. But that's the way that works. Question, how long can NC State keep a copyright? Good question. When the author, when the rights holder isn't a person, but is instead a corporation or an institution, it's a flat 90 years. So for a person, it's life plus 70. Obviously, NC State, we hope, will live forever. So there is no life plus anything. So for NC State, it's just a flat 90 years. NC State creates something and then 90 years it passes into the public domain. Really, really good questions, really thoughtful. Thank you for asking those. So that's your first question. Who owns it, if anybody? We've talked about a lot of situations where nobody owns it at all. It's an idea, it's a fact, it's a pre-25 work. In that case, you don't have to ask the other two questions. You're done. If something's in the public domain, copyright doesn't apply. Use it, remix it, put it on a t-shirt, do whatever you want with it. It's yours and everybody else's to do anything they want with. If you can identify that somebody owns it, and in particular, if you can tell who owns that thing, Then you go to your second question. Is my use permitted under the law? In addition to the limitations I've talked about, copyright also has a whole set of exceptions of places where Congress has said copyright does apply here, but we don't want it to be enforced in certain socially valuable situations. And the easy example here is one that teachers rely on all the time. In section 110(1) of the Copyright Act, Congress says explicitly, things that are protected by copyright are protected by copyright. But if you're a teacher or student or other person in a classroom, and what you want to do is perform or display a legal copy as part of your classroom instruction, I'm going to show a movie to the class. We're all going to have students stand up and read parts from a play. We're going to sing a song or play a song on whatever medium you prefer. Congress has just said, don't worry about copyright. Teachers in the classroom doing that kind of work, that's what we want to happen. That's the way society advances and moves forward. So don't worry about copyright in that context. That's an example of an exception where Congress has said copyright applies except to teachers in the classroom performing or displaying, but not making copies necessarily, a legal copy, so don't pirate one, as part of classroom instruction. So doing the sort of stuff that makes teaching better and students better learners. And there are a whole host of those. There's a set of those for libraries and librarianship. There's a set of exceptions for religious ceremonies. There's a set of exceptions for agricultural fairs. There are all these different areas where Congress has said, the purpose of copyright is to encourage sort of learning and societal development. If we enforced copyright with teachers, with religious ceremonies, with libraries, it would just get in the way. So we're just going to carve out a specific exception that says, don't worry about copyright in that context. Question here is, what tutorials on YouTube constitute classroom instruction or would not? Yeah, would. Would tutorials on YouTube? Really good question. So this section 110(1) I mentioned here was written in the 1970s, and their assumption when they drafted it was it would apply to physical spaces. So I'm standing in front of a blackboard, or I'm sitting in a desk looking up at the blackboard. The way Congress was thinking about the issues at that time reflected the time in which the exception was written. So 110(1) is about physical, they call it face-to-face instruction. There is another exception, it's 110(2), it's right next door, called the TEACH Act, that's designed to apply to nonprofit educational institutions that are doing online instruction in ways that are analogous to the face-to-face classroom instruction that this face-to-face teaching exception covers. It was written in 2002 and it wasn't written very well. It's very technical, it's very confusing, and most people don't rely on it for a reason I'm going to talk about in a minute. But in both cases, the exception is predicated on sort of a nonprofit educational setting that's limited to a discrete set of instructors and students. So in the physical libraries, when we do a lecture in that space, this exception might apply, but something on the open web on YouTube probably doesn't apply. And even if I limited my YouTube access to a certain set of people, these specific exceptions that we've talked about probably wouldn't apply, although courts have never ruled on the issue, so I have to say probably not definitely. That said, there is a reason that a lot of the stuff that happens online and on YouTube is in fact permitted under copyright law. And that's because in addition to these specific exceptions that we've talked about, there's also this exceptional exception. This is fair use. If you've ever heard about copyright before, you've probably heard the words fair use because it looms very large. And this is the reason that fair use looms very large. All of those exceptions that we've talked about are very old and are very time-bound. They're set in a set of expectations about how people engage with each other that doesn't really fit with the way we actually engage with each other these days as often as not. The smart thing that Congress did was they built on an existing doctrine that the courts had been developing for more than 100 years called fair use. And they said, we need a catch-all exception too. We need an exception that's there for all the stuff we didn't think of or couldn't possibly have imagined or just didn't get a chance to write down. And that's what fair use is. If the exceptions are the tight ropes that we walk on, fair use often acts as the safety net below, so that even if you step outside of where the exceptions exist, fair use can still catch you. Because fair use is written to say, this is the exceptional exception in that sense. The upside to that is that fair use has been resilient and durable and has remained vibrant and important in the way we think about copyright. The challenge that comes along with that is a specific exception is easy to understand and interpret. There are a specific set of people, teachers and students, in a specific place, a physical face-to-face classroom, doing a specifically articulated set of things. They're performing or displaying materials as part of classroom instruction. So it's basically a checklist. If we're these kind of people, check. Doing these sorts of things, check. In these ways, check. The exception applies. So if somebody asks me, is this permitted under the face-to-face teaching exception? I can say, yes, it absolutely is, or no, it's probably not. Because fair use is flexible, it's not a checklist in the same way. There aren't a specific set of people doing a specific set of things. It's there potentially for everybody, depending on the circumstances. So that makes it a lot more complicated. That doesn't make it less important. That doesn't make it, I hope, scarier, but it does mean we have to be a little more thoughtful about how we engage with and understand fair use. So I'm going to dig into it a little bit. Because fair use is flexible and it's not a checklist, what we have instead of a check, 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 or check X, fail, no, is a set of factors to consider. And the statute, the written law, lists 4 things to think about. And I'm going to suggest that these are sort of 4 questions to ask yourself as well. If you've ever seen a presentation about fair use, you might have seen a set of scales. And the idea is these 4 factors are like stones that you put in the scales, and it sort of leans towards or leans away from relying on fair use. That's one way to think about it. The way I was given actually in law school is that doing fair use analysis is like making soup. And these 4 factors are the ingredients that you pour into the soup. And if a judge were ever to consider whether your use was fair or not, they would sort of metaphorically take a big wooden ladle and dip it in and taste it and go, that's good fair use, or that fair use smells terrible. It's that scientific, it's that exact, but it's that idea of an overall taste as opposed to a mechanical check or X. So these are the 4 questions to ask, or the 4 ingredients to the soup, depending on how you think about it. And again, let's go back to the example we saw at the beginning. Somebody took those 4 images from the Star Wars movie and they brought them into a meme. When they did that, I promise you, they didn't get permission from the Walt Disney Corporation. Instead, they relied on fair use. So these were the 4 questions that they asked themselves. The first question they asked was, what am I doing? The law says the first thing to think about when you consider whether something is fair or not is the purpose and character of your use. And what that means is when you're doing something that is society serving, that kind of makes the world a better place, that helps us understand the world better, particularly, but not exclusively, something that's not about enriching yourself, your fair use case is stronger. Your soup smells good. On the other hand, when you're doing something sort of selfish that just rips off somebody else without adding your own creativity, without bringing something new to the party, that's not a very strong fair use claim. So when we're doing something like extension, we're generally doing something that's not commercial, even if there's some cost recovery. We're not trying to make $1 million. And we're doing something that helps us understand the world a better place. There's a real clear society serving function there. When we're doing that stuff, our fair use analysis starts off on very good footing. We start off with a really good soup stock, as it were, when we're doing the sort of stuff that we tend to do day in and day out. And the law recognizes that with this first factor. So question 1, what are you doing? What's the purpose and character of your use? The second question to ask yourself is, what are you using? What are you borrowing from? And this second factor is specifically asking questions like, are the materials that you're borrowing without getting permission, were they widely available? Were they already out there in the world? Or were they closely held and you're making them more widely available? You're changing the level of access that the general public has to this thing. And then a second question, are you taking something that's deeply creative that reflects the creativity of that individual person? Or are you taking something that's more sort of descriptive and factual, that doesn't have as much of that person's creativity in it? And the easy example here is a second factor for relying on fair use in order to borrow a descriptive story from the newspaper is a strong fair use case. The newspaper's already been published, it's already out in the world, so borrowing some it kind of isn't as much of a big deal. And it's just describing something that happened. There's less of the creativity of the author in that descriptive account of yesterday, there was a car accident, right? That's there's less of that person. On the other hand, if I broke into your house and stole your diary, the place where you shared your deepest thoughts and hopes and dreams in a way you expected to be safe so that nobody else could possibly see them, and I republished your diary, that would be a really weak fair use claim because it wasn't already out in the world. I put it out there without your permission by taking your thing. And it's really personal. It's your heart and soul is in that in a really different way. Those are sort of the extremes of the second factor. The other thing I should say about the second factor is that we have now spent more time talking about it than most courts do. For most courts, the first factor is really, really important. I described it as the soup stock a moment ago. For most courts, the second factor doesn't matter very much. It's maybe a sprinkle of herbs on the top or something like that. And that's important to know first, because don't get too hung up on this factor because it can feel really weird and metaphysical. But it's also important to say, because even though there are four factors we're talking about, they're not four equal factors. Different factors can weigh more or less heavily. So when you think about fair use, spend a lot of time thinking about that first factor and not that and spend a little less time thinking about the second. Question from James, what about items on a web page? They are widely available. That's right. So when you think about the second factor, however much weight you give it, if something is available on the open web, that should strengthen your fair use claim. That should make the soup smell a little bit better to you. Now, there are four factors, not just one, and the fourth factor is maybe the least important, but that should be part of your calculus for sure. So what are you doing? First factor. What are you using? Second factor. The third factor, the third question to ask yourself is how much of somebody else's work are you using without their permission? The statute talks about this in terms of amount and substantiality. And the easy way to think about this is, did you use a lot or a little? Did I take the whole thing from somebody else's work or just a little tiny bit of somebody else's work? And that's a useful way to think about it. I would suggest, though, that the best way to think about the third factor is actually as related to the first question, what are you doing? With the first question, you say, I need to borrow this work in order to do something socially valuable. The third factor says, okay, how much do you need to do that socially valuable thing you talked about in the first factor, right? You said you need to borrow somebody else's work. How much do you need to do that good stuff? The easy example here is if I was writing a book review and I said, this book is terrible. It's boring and badly written and confusing and it's awful. Nobody should ever buy this book. In fact, here are two sentences from a 500-page book that I'm reproducing in my book review to demonstrate to you what a bad book this is, how bad the writing is. My purpose and character is writing a book review, and that's one that's favored under the statute. The amount and substantiality is the amount needed to illustrate what a bad book this is. And I can probably do that in one or two sentences. If I said this book is really bad, here's the whole book for free. See how bad it is? That's way more than I need, right? So the question isn't just a lot or a little, but how much do you need? On the other hand, if I was doing art critique, it might be impossible to use just 10% of a painting to do art critique. I might need the whole thing. The appropriate amount might be an entire work in some contexts. So the third factor isn't just, did you use a lot or a little? The third factor is, did you use the appropriate amount for the purpose you talked about before? What are you doing? What are you using? How much are you using? And then the fourth factor, is your work a substitute for the original? If I'm out there trying to sell my thing, are you giving away so much of it without my permission that nobody's going to buy my thing anymore because your work is out there for free? It's a substitute. It's important to say, though, going back to my book review, that the question isn't just, does your fairly used work create market harm? It is about that substitution question I just said. So for my book review, this is a terrible book. Don't buy this book. If you agree and choose not to buy the book because my book review was so lethal, that causes market harm, but not because the work is a substitute. You haven't said, well, I don't need the book anymore. I've got the book review. You said the book review persuaded me that the book is no good, right? So the real question here, the touchstone is this work a substitute for the original or not? Do you not need the original work anymore because of the market harm that's been done, because of the substitution that's happened? So those four questions, what are you doing? What are you using? How much are you using? And is your work a substitute, are the four questions to ask yourself when you're thinking through fair use. Let's do an example here. This is a GIF that made me chuckle from a Tumblr that talks through the scenario, and I've been on both sides. I've been the student and the professor in this situation, where you accidentally yawn while making direct eye contact with the professor. And in order to sort of make it funnier, they included this little, 2-second, 3-second GIF of a character from a popular TV show making an oh my gosh, I'm so embarrassed face. I guarantee the person who runs this Tumblr did not reach out to Fox and get permission to use these 3 seconds from this GIF. So what they have to rely on is fair use, right? Our first question was, does anybody own it? Yes, somebody owns the rights to this TV show. Our second question then is there an exception that lets me use it? There is no specific exception for making GIFs, because when we wrote the exceptions back in the 70s, a GIF wasn't a thing. So what they have instead is fair use. So they would think about those 4 factors that I've talked about. The purpose and character of their use in this context, I would say, is making a humorous observation about what it's like to be a student. They're telling a joke in some sense. And that feels like a pretty good purpose and character, the what are you doing question or factor. They're not, curing world hunger or something. It's not society serving in the sense that it's changing the world, but they're not making $1 million. They're just kind of trying to tell a joke that illuminates the human condition a little bit. So I'm going to say our soup starts off pretty good. This isn't the best soup that has ever been made, but it's with that first factor, that soup stock that we talked about, starts off pretty good. The nature of the original work, the TV show that they're borrowing from in order to add this GIF, is creative, but it's widely available. So you can see how the second factor is often kind of a wash. It's a little this and a little of that, and courts don't really worry about it too much. So our soup is still doing pretty well. Again, not the best soup that's ever been made, but pretty good soup. The third factor, how much are you using? Critically, what's happening here is they used, you could say just a little, right? This is 2 or 3 seconds from a 22-minute episode, or you could say from a 7-season TV show if you wanted, but they're using just a little bit. More importantly, though, the amount that they used is the right amount for the joke to work. If it was this same set of text and then a full episode of the TV show, that would be way too much, right? Not just because it's a lot, but because the joke wouldn't work as well. They're trying to make a joke about this specific moment of feeling chagrined, and they pulled the appropriate amount, these 3 seconds from the show, to make that point. The joke wouldn't work as well if it was shorter than that, right? So far, I feel pretty good about our soup. The purpose and character was strong. The nature of the original, kind of a mixed bag, but the amount and substantiality, the third part, I think looks like very, very well done. It's very well tailored to the purpose that they articulated. And then the fourth factor, the market harm. Is this a substitute for the original? Would anybody ever say, I was gonna go watch the TV show, this is a show called New Girl, the TV show New Girl, but now I've seen this 2-second GIF, I don't need the show anymore. Probably not, right? It would be hard to argue that a 2-second GIF is a substitute for an entire, even episode of a TV show, much less the entire show. So taken together, I feel pretty good about this fair use analysis. And I see there's a great comment in here, so let me jump into it in a second. The fourth question is, a volunteer required not to plagiarize on our Plant Toolbox site. How can you paraphrase uniquely a flower or leaf description on a plant that is commonly described? Is usually unknown. Okay, so the question here from Nell is about taking language, if I understand it, taking language that describes a flower or leaf description on a plant that's commonly described in a particular way in multiple sites. And you use the word plagiarize, which is an important piece of that as well. From a copyright standpoint, I'm going to suggest a short phrase that describes a flower. Leaves of 3, leave them be is the one that my sort of ignorant self knows off the top of my head. That generally that's the sort of word or short phrase that might not be protected by copyright. There's a set of related doctrines that have to do with what the law calls either a de minimis, meaning really little use, or what they call a savoir faire, meaning something that's so commonly used, that's just the industry norm way to describe something. If it's a word or short phrase to uniquely describe a flower or leaf, I would suggest that starts to look like the sort of work that copyright doesn't protect in the first place. If it's a paragraph or longer, you might start to say, well, that looks like more than just a short phrase. That starts to look like a paragraph or more. And then you might want to think about permission or fair use of these other things as well. But as a general rule, one of the tests the law uses in this context is there another way to accurately describe what has happened? And if there's not, if every single site describes this flower in the same way, because that's basically the only way to accurately describe that flower, those are situations when the law generally says copyright would get in the way here, right? If the only way you can describe this flower is it's this color and it's in this shape and it grows in this way, if you lock that up, we couldn't talk about flowers anymore, and that would be a problem. So that tends to be a place where the law generally says, let's get copyright out of the way. That said, you say quite rightly, we don't want to look like we plagiarized the other popular site. And this is an opportunity to say something I need to say several times, which is the law is only about who is permitted to do something. The law has nothing to say about attribution or credit or plagiarism or those sorts of things. That's a parallel set of behaviors that are just as, if not more important than the legal permission stuff, right? If I break the law, I can get sued. If I plagiarize somebody, I can't get sued, but I can get fired or shamed in my community or drummed out or seen as being a bad and unethical actor. It's important to think about the legal stuff, but also the ethical stuff. So you might say, I don't think copyright gets in the way of my borrowing that way of describing the flower, but I might want to provide attribution, not because the law says I have to, but because that's what a good ethical practitioner would do. And when you're relying on fair use, when you're relying on the public domain, when you're relying on any of these limitations and exceptions we've talked about, attribution is still really, really critical. And I'm going to say that like 5 more times, and it's going to be important every time I said it. Yes, and Patty, you said succinctly what it took me a long time to say. Plant descriptions are likely to be facts and not subject to copyright. So particularly when your description is really just factual, this color, these leaves, this whatever, that's exactly right. Those are very much like facts or words, short phrases that are not protected by copyright in the first place. Very nice. Thank you for saying that better than I could say it. So that's fair use in a nutshell. Another question here, really good questions here. Thank y'all for jumping these in the chat. Question about the purpose and character. When using an image, can you address using an article about gardening written by master gardeners for a free publication that is supported by the ads and donations? Is that fair use? Good question. Fair use generally says that first factor analysis about commercialization is about the way the specific use is happening rather than the whole thing itself. So if you are using something in an article that is available freely, you are probably doing something that's non-commercial. And I would argue, and I think courts would agree, that extension programs generally are society serving. This is not somebody trying to get rich. These are folks trying to spread good, accurate information so the world can function better. So I think that first factor generally favors the stuff that we do. So if what you're doing is also good in terms of the amount used, and it's not a substitute for a commercial market, fair use is often going to be a really strong tool for you doing the stuff that you want to do. Really good question. One more sort of gloss on fair use is starting in the early 90s, courts took these 4 factors and they sort of synthesized them into this question about transformation. They said, if you want to really think about fair use in a synthesized way, in a combined way, you can take those 4 factors and you can sort of boil them down to this question of whether your new work, the thing you made borrowing from somebody else, merely supersedes the original. Are you just free writing off what somebody else did? Or are you adding something new with new expression, meaning, or message? In other words, did you just take somebody else's thing and show it off without adding anything new? Or are you recontextualizing, representing, commenting on in a way that is what a court would call transformative? And then if it is transformative, are you using the appropriate amount? Yep. And yeah, Nell, I see what you say as well. Yes, everything about the plant has been described, so it's difficult to think of a different descriptor. So that's another nice way of saying, yeah, that's likely the case that the law would permit you to do that sort of thing. So transformation is a way to take those 4 factors. What are you doing? What are you using? How much are you using? Is this a substitute? And you can see a nice example of that here. This is a coffee table book about the Grateful Dead that was released a while back. There was a big lawsuit about it. What happened was that the scholar who's creating the book took a bunch of concert posters from Grateful Dead shows. They reproduced them. They actually sought permission. They reached out to the rights holder, but they couldn't come to terms. The rights holder in the concert posters and the author couldn't agree on how much to pay and what the terms would be and that kind of thing. So they never struck a deal. The author nevertheless included the posters anyway, and there was a lawsuit. The rights holder for the poster said, you asked my permission, you didn't get it. In fact, I denied you permission, and then you went ahead and used it anyway. I'm suing you. And the author said, I don't think so. I think this is fair use. I took these concert posters that were designed in order to get people to come to shows, and I reproduced them in a transformative way. I used them specifically to create a timeline of the Grateful Dead over the years, to say that in 1967, this is what the culture was like. This is the way they were talking about it. This is where they were playing. By 1973, this was happening. And I added a lot of new stuff. I added annotations. I added scholarly gloss. I presented them in a new way. This is transformative. This is fair use. I didn't need to get permission in the first place. And a court agreed. A court said, what you have done was not just selling a big coffee table book of Grateful Dead concert posters, or even using the posters to get people to come to a show. What you did was a scholarly recontextualization and analysis, a close reading in some sense. That's transformative use. So that's one nice example of taking something and transforming it through the sort of creative scholarly work that we often do. The question here, can the picture of a plant be taken from a company site for a PowerPoint or flyer? So if I understand the question correctly, the question is there's an online site that has a picture of a plant, and we take it and add it to a PowerPoint or a flyer. And I think the answer to that is going to depend on those sort of either the transformation analysis or those four factors. Like, what are you doing? What are you using? How much are you using? And what's the market for the original? The way I would answer that specific question is, why did you choose that particular image rather than another? Is there something about that particular image that's uniquely significant for the work that you're doing, that's transformative? Or did you just need a picture of a flower and that was the most convenient one there? The more your purpose and character reflects that transformative idea we talked about. I'm doing this work and I need this particular image to illustrate this idea or to demonstrate this concept, the stronger your claim can be. So from a legal standpoint, that's the way I would think through that question. From a pragmatic standpoint, if there's another way to find a version that's not owned by a company that might be angry or sue you, I'd investigate that option as well. And that actually takes us to the next thing. Say quickly, there are these great codes of best practice and fair use for different communities that offer nice ways to sort of put into practice some of the things that we've been talked about. So sorry, quick question. Was Lee's image question different from this one just above? So yeah, so Deborah says you can ask them if you can use it with attribution. Yes, and I'm gonna mention permission in a question in a moment. That's always the case. If the picture is used to educate folks, that's a good purpose and character of your use. Oh, and Lee is asking about the Creative Commons definition of commercialization. That's a really good question. I'm gonna quickly introduce the Creative Commons so we all have that, because we're getting into these really good questions about permission. So I'm going to come back to that question about Creative Commons and commercialization in just a second, because it's a really good one. So just quickly, so we're all on the same page, those three questions to decide if you can use somebody else's work. Is it, does anybody own it? If the answer is yes, move on to the next question. Is there a limitation or exception that permits me to use it? If the answer to that is no, this is not fair use, or I'm not confident it's fair use, then we get to these questions about permission. And if you get permission, you can also sort of jump to that and not worry about the fair use stuff as well. There are a couple of ways to get permission. The first is to ask permission directly, right? Charlotte has a great image. I want to use it. I just send her an email. I say, hi, this is a cool image. Can I use it? And Charlotte says, sure, of course. Okay, I'm done. no worrying about protectability or fair use or anything else. We've taken care of it. I include this because the Duke ScholarWorks site has a nice model letter for requesting copyright permission. If you need to ask somebody, that's a nice place to start in terms of drafting your ask. I generally suggest using plain language rather than lawyer's language, because everybody in the world would rather have a friendly question from a peer than a formally worded legal question, right? So you're more likely to get a good answer if you say, hey, friend, I'd like to do this thing. Is that okay? Than if you get a lawyer to draft a very legalistic response. But the questions that I've seen here are about Creative Commons, and that's the next place I wanted to make sure we got to as well. And yes, we'll put the link in the chat as well at the end. When I share screen, it's hard for me to add stuff, but I'll do that in just a second. And Christina says that many sites are designated by the owner as copyright in total versus each photo being copyrighted. That's right. So there can be copyright on a website as a whole, including all the photos on that website. An individual website can have different copyright status for different images that are hosted on that website as well. So notice those terms of service for sure. One of the best ways to find, especially if you just want a pretty song for the background of my video or a picture of this kind of flower, are these sites that host Creative Commons licensed materials. I've seen a couple questions in the chat such that I suspect a lot of you all have heard about Creative Commons before. So I'll say this very quickly, but ask more questions. The Creative Commons is a nice way to put an open license on something that says, I'm the rights holder, this is mine, but I hope you'll use it as long as you use it in certain ways. This is my thing, please use it widely, do anything you want, but make sure my name's attached to it. That's the CC BY license. This is my thing, use it, but provide me attribution. And then there are a set of other requirements you can put on a Creative Commons license. This is my thing, you can use it non-commercially, but if you're gonna try to make money off of it, then you're gonna have to have a conversation with me. I don't give you blanket permission to commercialize my work, just to use it non-commercially. And to the question that was asked a moment ago, when the Creative Commons uses the word commercial or non-commercial, what they usually mean is, are you commercializing the image itself? Are you selling access to the image either directly, come to my site and pay me $10 for access to this image, or indirectly? This is a copy table book of 50 beautiful images of flowers. I'm selling it at Amazon.com. That's commercialization. On the other hand, I'm going to put this on slides that I'm presenting at an extension event. Clearly non-commercial use. We're not charging, a fee for people to access that. We're doing it for that sort of society-serving purpose, right? A flyer to promote my stuff. Likewise, not a commercial use. So if you see something that's labeled CC BY NC, it's available for non-commercial use, and that includes the sort of things I just talked about: a non-commercial presentation, publicity for an extension event, that sort of thing as well. The other two limitations they offer, by the way, are share alike, which means you can use this thing as long as whatever you build with it has the same license as this material that I'm borrowing from. People sometimes talk about that as viral permission, and it's a way of saying this open ethos is important to me. So if you take my image and build it into a slide deck, that slide deck has to be licensed with that same CC BY SA license as well. Respect my values in your downstream use. And then the last is the ND mark, which stands for no derivative works. And that means you can take my thing, but don't change my thing. I really agonized over the lighting and the posing in this photograph. Don't crop it, don't re-edit it, present it just as it is. Or one that you often see as well is, this is a guide to how to treat, if you're bit by this snake, here's how you treat the venom. Don't change that. It's really important for people to have the best information about medically responding to getting bit by this snake. Don't mix it up. Don't cut an important part of the process out. Respect the integrity of my work in terms of the way other people see it in downstream use. And then you can mix and match those. You can release CC BY or CC BY NCSA or any sort of permutations there. I will share a link to that as well. So thank you, Charlotte, for the Creative Commons licenses and the Duke Scalcom toolkit link. Christina says non-commercial includes extension under Master Garden Association plant sales, correct? Generally speaking, yes, because you're not commercializing the image itself. you're just selling the plants, right? So that's when I say Creative Commons is concerned about the use being made. The way you're using the image is not commercializing the image itself. So yes. Is there somewhere that says what NC, ND, and SA are? I think Charlotte's link hits some of that stuff above. I'll share it as well, but I'm going to share these slides and you can see the copy and publish, attribution required, commercial use, modify and adapt. That's also a nice way to understand the way the different licenses work. Really, really good questions. I'm going to acknowledge we're at the hour mark here, so if you have to drop off, that's totally okay. We're just about to the open Q&A session, but we've had really good questions so far, so I'm really happy with all the conversations that we've been having. Quickly, if you're looking to find Creative Commons stuff, CC has a federated search that brings together everything they know about, so you can go to search.creativecommons.org. There are also individual sites. I use a site called Pixabay, sometimes for images. There's a site called CC Mixter that has music. So if I'm making a video and I want exciting music or soothing music or whatever, there's openly licensed music in that space as well. So you can go to media specific sites, or you can go to the CC federated search. The other place you might see Creative Commons licenses is in the Extension Gardener Plant Toolbox. I pulled up an example here. They don't have a site-wide statement about Creative Commons licenses, so you have to go image by image. But you can see on this example here, I've put red boxes around. The first image has a CC BY SA 3.0. So this is my thing. You can use it as long as you give me attribution by and release whatever you make under the same license, SA, share alike. The second one is also CC BY SA as well. My sense from a quick look is that many to most of the images in the plant toolbox are openly licensed. But because it's not done at the site level, it's done at the image level, you'll need to look at the information about a particular image to know specifically what you can and can't do with that stuff. Great question about the 3.0. So all the original Creative Commons licenses were released in the mid-2000s, and it was CC BY 1.0 or whatever. What they found over the years was that there were a few things that were confusing to people or maybe could have been worded a little bit better. So they released the CC BY 2.0 license. And they said, here, we've clarified a few things. We've cleaned up the wording a little bit. It was a bunch of really smart lawyers, but stuff can always be better. A few years after that, they released the CC BY 3.0, slightly updated. And most recently, they've released the 4.0 version of all the licenses. So it just means that it's a newer license. The nuances that they have addressed are pretty deep in the weeds. The difference, pragmatically speaking, for a 3.0 versus 4.0 are pretty minuscule. They often have to do with weird sort of international treaty stuff. But that's what the 3.0 means, is that this specific license applies rather than the 2.0 or the 4.0. There's a nice chart I'll share that spells some of that stuff out. John asks, what does attribution looks like? What needs to be posted? There's a really nice resource that I'll share that gets into that in some detail. I'll say quickly that the two things that CC says about that are they give you some latitude to do attribution in the context of the individual community and of the resource itself. So there's not a requirement, for example, that the attribution has to be directly below a specific photograph. You could have a slide at the end of a slide deck that provides attribution for all the images used. Or if you're doing a movie that's on YouTube, you could put the attribution at the beginning or the end of the movie, or in the metadata about the movie. There's some latitude to do it in the way that makes the most sense for your content. What they do say, though, is that when you do attribution, you should generally try to abide by, they call it TASL, T-A-S-L. Your attribution should have the title of the work, T, the author of the work, A, the source of the work, S, and the license it was released under, L, T-A-S-L. So you can see this is a nice example here of TASL. The title is Flowers, the author is Stan Shebs, the license is CC BY SA 3.0. And if I wanted to make it even better, I would probably make the word flowers hyperlinked out to whatever the source of that is. So that might be Stan's site, or it might have been found in an aggregator or somewhere else as well. But if you do those four things, title, author, source, language, TASL, you will generally be in good shape, as long as somebody can clearly understand what the attribution applies to, whether that's directly below the specific image or in an informational slide in the back or anything else as well. Really, really nice questions here. So something I've said before, and I'm going to say now, and I'm going to say again, everything we're talking about so far is what the law compels you to do to get permission to do something. None of this invalidates or minimizes the importance of attribution in ways that are respectful and accurate and give credit to the people who are doing the work to create this stuff. Even if it's fair use, even if it's public domain, even if there's a CC license or whatever, that attribution stuff is super important. So the question, I should clarify my question, if an image is marked NC, can it be used to show a flower or a plant on a plant sale flyer or website? Yes, unless you are selling the flyer itself. If you are commercializing the image, that's commercial use and you can't use an NC image. If you're using an image in a way that is not commercializing the image itself, or otherwise being used in a clearly sort of commercializing the thing concept, then that's the issue, right? So NC is fine in that case. Really good question. Thank you. And thanks for asking for the clarification too. So we've talked about the baseline of ownership. I hope you'll agree it's pretty straightforward. You make it, you own it. You can give other people permission to use it. We've talked about using other people's work and the 3 questions to ask. Does anybody own it? Am I permitted under the law to use it? Or do I have permission, either explicitly from the rights holder or through a license like Creative Commons? The last thing I wanted to say before I open it up for more questions and discussion is I'm not saying anything you don't know to remind you that when we share our work, that often comes with a set of requirements and strings as well, and I want to point to those. So going back to my example at the beginning, we've talked about the several different people who have an ownership interest in this thing. We've talked about the way, or I'll say explicitly here, I think fair use irons out a lot of that distinctions. I don't think Lenny has to worry at all about getting permission from Disney or from whoever came up with the idea of the meme or anything else, because I think fair use irons out those details. Likewise, I feel fine using this without Lenny's permission because I think fair use permits me to do that as well. But Lenny is using Twitter to share her work, and Twitter does have a set of terms of service. You can download Twitter's user agreement there. Basically what it says is you retain rights to your stuff. You're still the rights holder in anything you own, but you give Twitter a non-exclusive license to share it. And they need that, obviously, because otherwise you could post an image and then sue them for using your image. They need a license. But it's a pretty broad and sweeping license. So be aware that when you share something, for example, on Twitter, they are taking some of those sticks from that bundle of sticks I talked about at the beginning to use their stuff as well. You should also be aware that Twitter says, generally speaking, if there's a lawsuit, if Disney decides they do want to sue Lenny, that's Lenny's problem. That's not Twitter's problem. They have very explicit language that says, this is by and large on you. And most sites are going to have terms of use or terms of service that say some version of that. YouTube has the same set of this is still your thing, but we can use it in certain ways. And if there are any lawsuits, that's your issue. YouTube obviously sort of operationalizes that through the content ID system. And if you really want to nerd out about that, I'm happy to talk about that as well. Bandcamp and some of the other sites as well. If you're sharing, I'm trying to do text, video, and music, and Bandcamp is the one I tend to see for music most often. If you don't feel like spending the next several years of your life poring over end user license agreements or terms of service, I wanted to point to this site, Terms of Service Didn't Read, which is a really nice website that brings together sort of plain language analysis of what the different terms of service and terms of use say. I'm thinking about using Bandcamp or WordPress or Twitter or whatever. What does that mean for me in terms of privacy, in terms of ownership, et cetera? This is a nice resource to understand that stuff. And they give a letter grade and say, like, this is an A+ site. They do a good job with letting you retain your rights and respecting your privacy. This is a C- site. They do a pretty mixed job, et cetera. So that resource I wanted to share quickly. So Andrea has a question. Are copyright owners allowed to change the copyright of an image or whatever as time goes by? Really good question. So copyright owners can say, this is my thing, all rights reserved, and that never changes. They can then choose to openly license or grant permission to something, and their ability to change that is based on the specifics of the way that permission is granted. So if you gave me rights to use your image, we could say, I give you permission to use that forever. We could say, I give you permission to use that for 2 weeks. Or we could say, yes, you've got permission. I'm not going to specify how long that permission lasts. The presumption is that that permission lasts forever or until some circumstances change, but it's better to make that explicit. The way the Creative Commons makes that explicit is they say, these licenses are irrevocable. Once you put a CC BY license on something, that resource is CC BY licensed forever. What that means is if you find something with a CC license on it, nobody can take that back. The rights holder can't down the road say, you know what, more people are using that than I thought. I don't want to have that openly licensed anymore. They can't revoke that license. So CC licenses are nice for some of the reasons that we talked about, but also because you can be sure that they'll always be there. Last year during the pandemic, a lot of publishers generously gave us libraries the right to share certain resources more openly in the context of the pandemic. And that was nice of them, but that permission was often given in a way that was sort of unclear and definitely short term. And then after a while, they basically said, now you can't do that anymore. We're not going to give you that permission anymore. And all that stuff went away. CC licenses don't do that. If you've got permission to use it under a CC license forever and ever and always, you've got permission to do it until copyright expires. And then you've got the ability to use it because permission isn't needed. So Diane asks, if a photo is in the public domain, according to Creative Commons, attribution is not required according to your chart. Are you saying it's still bad manners not to provide it? A couple of really good questions in there. The first thing to say is a Creative Commons license is a little different than the public domain. A Creative Commons license is somebody saying, this is protected by copyright and I own it, but I give you permission to do certain things. If something is in the public domain, nobody owns it and anybody can use it how they want to. I'm getting a little nerdier about that because there is also a Creative Commons public domain designation. If you are the rights holder to something, you have the ability to say, this is my thing. I don't even want CC BY. I want to dedicate this work to the public domain because I don't want to worry about copyright anymore. So there is a difference between either a CC public domain designation and the other licenses as well. Yeah, so CC0 is there, which there's, again, we're getting really nerdy here. There is a CC0 and a CC public domain dedication. CC0 is sometimes used for things where somebody says, I don't think there was copyright in the first place. You'll see CC0 on data sets sometimes, where like, I think this is factual. I don't think this was ever protected by copyright, and I'm gonna mark this and say, my understanding is no copyright. The public domain designation is often, this is protected by copyright, but I don't want it to be anymore. So we're way into the weeds there. I'm sorry, I'm nerdy about that stuff. So that's the first part. The second part of your question, and I think part of the question, the part that you were more interested in is the chart says attribution is not required. The question is it still bad manners not to cite it? And my answer to you is the law can tell you what you have to do. And a CC BY license says, in order to get this license, you have to do attribution. That's a parallel conversation to what you think the ethical thing to do is. So you could say, it's nice you don't say I need to give you permission, attribution. I still want to give you attribution. That feels like the right thing to do to me. On the other hand, you might say, well, you released it under a license that doesn't require attribution. Clearly, you know you had that option and you didn't choose to use it. I guess I don't need to do attribution. The question, though, is ultimately an ethical one rather than a legal one, right? I've heard people say attribution isn't about just giving credit to the author. It's about providing good information for downstream users. I want whoever sees my flyer to know who took that great picture. So I don't care whether the photographer wants credit or not. I want to give that information to the people seeing my flyer. Those are questions that a lawyer can't answer for you that are just about what does an ethical good practitioner do. So make the decision that feels right to you and know that the law isn't going to second guess you on that. Question from James, if I use my own photo in a blog, should I post then the photo's copyright status? Good question, James. The default, if nothing is said, the default is that all rights reserved, right? So if you post a photo on your blog with no more information about it, about copyright at all, you have retained all rights in that photograph. But I, as somebody who's reading the blog, might not know that. So if your intention is, I'm posting this on the web, but I want to make sure nobody uses it without my permission, it's not a bad idea to share that information, not because you have a legal obligation, but just because it's good information for your folks to have. Same thing with a Creative Commons license. There's a legal function there, but there's an informational function as well. This is my thing, attribution is important, and I don't care about the rest, and I want to make $1 million or whatever you want. So the law never requires you to do that, but it's often a good idea to do that. Question for the Top Hat project, we're giving attribution to anything under CC0 or public domain. Thank you for sharing that, Anna. Absolutely, that's a night you're not required to by the license, but attribution just feels like the appropriate thing to do in this context. So you're totally not just within bounds, but you know, it's great to do that as well. And yeah, Charlotte says, Anna, that may be a Top Hat requirement as well. I don't know the specific terms of Top Hat's requirements, but I could imagine them saying attribution feels like good practice to us. If you're using our stuff, we need to have attribution in that space as well. I think I have gone back through most of the questions there. We have come to the end of my blathering on at you and to the time that I wanted to reserve for your questions. So please share them now. If you posted to chat and I missed it, feel free to repost it or unmute, or just to ask questions now. So Anna says, yes, it is a Top Hat requirement. Makes it possible for you to track down an image for reuse. That's a really good point. Absolutely, that information is useful for downstream users in that way. Top Hat, I'll say a little, and other folks feel free to jump in chat or unmute as well. Top Hat is a platform that hosts educational materials that sort of wraps them up with a nice bow in some ways. I bet other folks can say more and better about that than I just did. I know them in the context of open educational resources in particular. So Charlotte has a question. Gardner newsletter, we're relatively new. Thanks, okay. Sorry, I lost my chat there. Relatively new group and sometimes need to use articles or photos from other extension offices. Do we need author permission to use articles or photos for our newsletter? We've been told we could use any and all extension office information as long as we're working within our extension. Yes, so way back a little while ago, I mentioned that extension retains rights to most of the materials created by extension. That's the #1 reason that decision was made, is so other people in extension wouldn't have to track down an author who retired 5 years ago or moved to another state or whatever else, that there would be a clear way to understand if you see that extension mark on there and you're doing extension work, you can reuse that stuff. That was the thinking behind extension retaining copyright in those works, was for ease of other extension folks to be able to use and build upon that work. So yes, that's accurate. Unless otherwise marked, you can assume that you are free to use extension materials in other extension materials, as it were. Andrea says, I've contributed a lot of photos to the plant toolbox with a CC license of your choosing. Over the last 5 years, you've contributed photos to NBBook without a license. How do people, I don't know, want to use those photos? No, they are copyrighted, even if by NC State extension. Good question. So the question is about sometimes the photos have been marked with a Creative Commons license and sometimes they haven't. As I say, if they have the CC license, it's very clear who owns them and what can and cannot be done with them. If there's no licensing information on them, the presumption is copyright remains with extension. But of course, generally speaking, the idea is that stuff is shared widely. So that's where a license makes use clear and ownership clear. And if that license isn't there, then we just sort of go back to the default ownership. Lots of good questions coming in here. Let me get back to them. If I write an article for the newsletter, can I use it in another non-extension context? I believe under the law, depending on what other conversations have been had, you would want to go and ask extension for permission to reuse that. You would say, I wrote this article, I'd like to use it in this other context as well. I have not heard of situations where the answer to that has been no, but I believe unless there have been other arrangements made, that's the person you would go to clarify that, is somebody else from extension for use in non-extension, because it is something that is controlled by extension. Anna shares some great information about Top Hat and its relationship to the NC Extension handbook videos and slide presentations here. Thank you for sharing that information. That's really helpful. So they tell you on extension, master gardeners can use anything on .edu websites. Is this true? No, this is not true legally speaking. Practically speaking, you are likely to find folks who are not commercializing and are happy to have the eyeballs on their work, but there is nothing in the law about a .edu website being free to use in any sense. So that feels like a reasonable rule of thumb for finding folks who are not commercializing, but that's not grounded in the law itself. I would start with Creative Commons sites first, and then if you can't find something there, but you find something at a .edu, you can reach out to the, if it's on an edu extension site, the extension folks, if it's on a faculty member site, to the faculty member, et cetera, and ask about permission that way, or rely on fair use if you think it's fair use. Question from Deborah, do you have to submit photos to CC for licenses? What's the process? Really good question. No, the Creative Commons license is just it's a thing you can put on a photograph or a website or a song or whatever you want. There's an online license chooser that you can use to generate the digital license, and that then goes into the code on the website so that sites like Google can discover openly licensed materials. You probably know that in Google image search, you can sort so that only Creative Commons licensed images show up. That's the digital version of it. But honestly, you can see on my slides here, I've put a Creative Commons license. I just dropped that image in the lower left hand of that slide. There was nothing more to it than that. I have a PNG of a Creative Commons license, and I added it to the slide deck. And that's all you have to do to manifest your intention to openly license something. As I say, if you want it technically digitally discoverable, you can add code to an online or digital resource as well, but that's not a legal requirement. That's just about increasing discovery. Really, really good questions, folks. So in course and scope of my employment with Extension, I use my own photos to augment an article I've written and published on Extension website. Does Extension now own those photos? Not generally speaking. If you already owned those photos prior to adding them to Extension, you didn't create them in the context of Extension, so you would retain rights to those things. In that case, you would want to really clearly label that so there's no confusion. And you probably would want to check in so there's no confusion. But no, simply contributing something to Extension doesn't change ownership if it wasn't created under the aegis of Extension. In the same way that if you brought in a photo under Creative Commons license, those things don't belong to Extension anymore. The existing copyright still applies. Regarding a presentation for Extension, the site ABC specifies the required attribution format as author and organization, ABC. They don't mention citing the title of the work or CC license. You've used their format. No, you do not have to go back and use their stuff, specifically because if it's not a Creative Commons license, then you don't have any obligation to use their TASL framework, right? I could share my work and say, if you want to use my stuff, you have permission as long as you cite me as Will Cross, the most handsome man in the world, right? I could make some ridiculous requirement for attribution that you could accept or deny, but anybody can create their own rules for what they consider attribution if that's a condition of the license. So if you're abiding by the specific terms of the license, Creative Commons or ABC or whatever, you're doing what you need to do legally, and the rest is just about ethics. So Deborah says, I understand that if you claim volunteer hours for an article you wrote or a photo you took, then the article or photo is owned by NC State. It may be that claiming hours in that context is considered within the scope of employment. I don't know the specifics of that. So I would ask a peer or supervisor what their understanding is. And we can take that all the way up to council to get total clarity about that. But yeah, the question is going to be whether it was made, quote, within the scope of employment. And that can be about money or hours or credit or using the branding or any number of other things as well. Y'all, this has been a very fast hour and some. I appreciate all your wonderful questions. Sheila says, clarifying all your question, the site ABC is using CC licensing, but does seem to mention citing the license. Okay, great, I appreciate that, yeah. If you're using CC licensing, then CC's approach makes the most sense. Generally speaking, what Creative Commons says is creators and rights holders have the ability to define how they would like to be attributed, if at all, right? You'll sometimes see, I'd like to be anonymous, please don't include my name. In the absence of anything more specific from the rights holder, that TASL framework is a good default, but that default can be modified by the creators.
Well, one question we might have missed is from Anne, talking about adding a credit or a license information directly to the photo, you know, like in the small print, the lower corner. Does that violate ND license?
It might. I don't think anybody's ever been sued over that thing, but you could imagine that exactly that objection, that my no derivative work said, don't change my photograph. Putting text over my photograph feels like a change, so don't do that. As a general practice, I tend to avoid ND licensed stuff because remixing is an important part of how I do my work. And so you might say, if it's important to you to be able to put the attribution over the image itself rather than sort of beneath it, you might say, well, ND's not a good fit for me then.
Great, thank you.
Yes, and thank you, Pat. That's high praise. I appreciate that. I'm really happy to hear that, Lee. Thank you.
I had a question on behalf of an extension agent who emailed me who wanted to know if photos on PowerPoints created by other people in extension, can they pull those and use that, kind of under this understanding of it's all an extension?
Generally speaking, if you don't see a Creative Commons license or an all rights reserved to this person or that person, I think you can generally operate under the assumption that the PowerPoints were created under the aegis of extension and thus are controlled by extension and are available for other extension officers to use. It's a long way of saying yes.
And I have a related question. So in creating a PowerPoint, say you as an extension person are creating a PowerPoint with the intention of sharing it with other people, like making it available to Master Gardener volunteers to present or other agents to present. Does fair use apply there? So, you know, if you're making it and you're pulling images with the intention to redistribute within extension, does that fit fair use?
So let me make sure I understand. You find a PowerPoint and you're going to reuse it sort of internally. You're not going to share it with audiences in the public. You're just going to share it with other extension officers as a way of, this is a cool way to do this. Or did you see this great slide deck? Or, oh gosh, let's never do it like that. Is that your question?
No, it'd be more like if I was creating it with the intention to share it with other agents or volunteers for them to present. So they're going to present it to the public for programs. Okay.
Yeah, great question. So the answer is that fair use will or will not apply the same amount, if that makes sense. So those 4 questions, what are you doing? That purpose and character sounds pretty good. The fact that you are creating it for others to use doesn't diminish the social value of the work. If anything, it increases it. And if your use is transformative in the ways that we've talked about, fair use is still fine, right? So I don't hear anything in your question that changes the baseline calculus about, you know, is this work a substitute, right? So the reverse example here is if you went to a pay photos, you know, a stock photo site where they expected you to pay a licensing fee and you just didn't, that probably wouldn't be fair use because, you know, it's not transformative and there's clear market harm, right? The fact that if you did that, that would not be fair use if you did it yourself or if you shared it with other people to use. On the other hand, if you found something that wasn't in that environment that was okay to use and your use was fair for your own use, your use is still fair if you share it with other people to use. So sharing it with other agents probably doesn't change the fair use analysis much.
The question, if you're showing a image of a commercial product that you took off a website, would that fall under fair use?
Good question. The answer probably depends on how and why you're showing that image. If you're saying the best commercial product to use in this situation is this one and showing an image, that's pretty likely to be fair use. If for no other reason, then hard to imagine the company being anything but delighted you're doing that, right? Like it's fair use because you're not commercializing it. You're doing it for the purposes and character that we've talked about. The nature of the original might even weigh more highly because it's probably a sort of a factual, this is what the commercial product looks like. The amount is appropriate. And then it's hard to imagine there being market harm or substitution in that case as well. Some people sometimes say that the fifth fair use factor is who's going to be pissed off at you, who's going to be angry at you. That's not actually in the law. That's just sort of the risk analysis piece of it. If you're doing that in a way that you're saying this is the right tool for the job, nobody's going to be really angry at you. If you are saying people are going to try to tell you this tool and it's terrible, you should never use it, your legal case is just as strong. If anything, it's a little bit stronger, but the chances that somebody's going to be angry at you might go up a little bit too. So you'd want to sort of double check the rest of your fair use analysis to be sure if somebody does get angry, you can say with confidence, yeah, I know you don't like it, but the law says I can do it. I'm providing a valuable service. Your product isn't very good and folks need to know it.
Well, I have a question to clarify something that you said earlier. If you solicit photographs from master gardeners for use on Facebook or in an article or whatever it may be, and they've taken the photographs previously, so they've just got all their photos, saved, but they're now going to help you out. Do they retain ownership of that photo because it wasn't taken for extension purposes, even though it's now going to be used for extension purposes?
That's a really good question. The baseline legal answer before we get into the policies, they would retain ownership rights because they weren't hired by extension to do that work. Somebody said in the comments that it may be that if you are claiming hours, that if you are getting benefits, even if they're not financial benefits, that might be considered within the scope of employment as well. I don't know the answer to that part of the question, but I would ask a peer or supervisor about that in particular. But the baseline without the policy would be no, in the same way that incorporating a Creative Commons licensed image doesn't give extension ownership of that Creative Commons licensed image. So that's a hazy, I don't think so, but check with folks on the ground. And I see Charlotte's adding here. Okay. As a condition of serving
I dropped
and
the
participating.
actual wording again. Yeah.
Thank you. Okay. Created or developed by volunteers while performing within the scope of their roles, duties, or services. And then they provide a royalty-free license. They do not own the copyright to works created or developed by volunteers outside their roles, duties, or services. Okay, so that sounds like a better way to say what I have been trying to say, which is if you made it outside of that scope, you retain rights. If you made it within the scope, rights belong to extension. And state puts an open license on it anyway, right? There's no land grab here to make $1 million. There's just a policy written with the intention that as many people as possible can use it with as few headaches as possible. Okay. You all have been with me for more than an hour and a half. Who knew that copyright could be so exciting? So the question about copyright marking, yes, I would absolutely make it clear if your intention is this photograph is being included, but I want to make it clear that this is not owned by extension, I would clearly mark that for sure. Copyright is exciting. I agree, Andrea. Great. Well, you can see my contact information down there. I'm always happy to chat about this stuff anytime. I love this stuff. So if you have questions, I'm always happy to chat. I always say I am a lawyer, but I can't be any particular person's lawyer. I can't help with parking tickets or anything like that. So I can guide you to good resources and talk you through issues if that's ever useful. I really enjoyed the discussion. I hope it's been useful for y'all as well. And I'll appreciate all the great work you're doing.
Thank you, Will. We greatly appreciate it. And if you do have one more minute, I would like to pick one more question that came in because it's a great follow-up
to
the copyright policy that says, so if you took this picture outside of the scope of volunteer work, say, you're just a master owner volunteer, you take pictures in your garden just to have for yourself, and then your agent asks, does anybody have a picture of this plant that I can use in a PowerPoint? Does that then become copyright when you specifically give it to Extension to use?
I don't think so. My reading of the policy, and again, check with local folks to confirm this, my reading of the policy is the picture wasn't created within the scope of extension work. It's just been borrowed by somebody in extension for this purpose. So just like any other third-party material brought in, it's used under permission, under a license, rather than because extension claims ownership of this thing. Extension owns the slide deck where it's incorporated, but that's why the image itself should be clearly labeled as this is not, the ownership of this thing is different than the ownership of the slide deck as a whole.
Okay, so maybe if an agent was concerned about having permission to always use that photo, they would ask a volunteer if they're willing to contribute it with a Creative Commons license.
That would be ideal for sure. Yep.
That's great. Thank you. It helps a lot. And everything today has helped a lot. This was tremendous. We really appreciate you spending this time with us, and as people have commented, making what could be kind of a dry topic very interesting and entertaining.
Yeah.
And understandable.
I'm glad to hear that. I said at the beginning, not so confusing, loves and supports the work that you do. So I hope I've persuaded some folks about that for sure.
Definitely. And I'll just finish off with one more comment I wanted to make about the copyright policy for the Extension Master Gardener program. Was it really was put in place, as you said, to make it as hassle-free for people to use images. So NC State's not trying to own everybody's images, but we just want to make sure when people contribute images for use in the program that we don't have to worry about in the future, losing that right. So I think a best practice for us will be to ask for things with Creative Commons license if they were pictures taken outside of your role as a volunteer. So
yeah, my sense is that there when it was revised a couple of years ago, there were some like, this is an amazing website and the person just retired and moved to somewhere else and now we can't get permission to use it. And what do we do? It really comes from those trouble spots. So thank you for saying that so well.
Yeah. All right. Well, thank you, everyone. And this has been recorded, so we will be sending the recording out. Will, you said you were going to share your slides, did you, in the chat at the beginning? So we'll make sure to include that in the follow-up email and any other resources that you recommend. I've been capturing, and Caroline's been capturing links and things as you go through, so we can make sure and share those back out. But if you have anything else you recommend, let us know, and we'll post it for everybody and make sure they get it as a resource.
Thank you for your help.
All right. Thank you.
Take care, everybody.